Congressman Mike Johnson is here for a little bit. Hey, Mr. Mike, how are you this morning?
Hey, my friends, doing well.
Well, you're not here today as a congressman. Well, yeah, kind of, but more as a lawyer, to be precise, a constitutional lawyer. There are specifics now. There is a new, how would I phrase it? A new
policy
put in place by the Bossier City School Board, the school district, on how teachers, what they can and can't do when students start to pray. Give us a little background on that. Tell us more about this Freedom from Religion Foundation and the purpose.
Your buddies.
Yeah, right. And the purpose in your mind for these Bossier changes.
Well, listen, this is my personal opinion, okay? I'm not the attorney for the board anymore, obviously, because I'm serving in Congress. But I used to be their attorney on a number of these matters, and I did this all around the country. And you're right, this other group was one of our nemesis organizations. They have a radical view of the country, and they're on a search and destroy mission for all things religious. But, I did this for nearly 20 years, as you guys know. I fought landmark religious liberty battles successfully in federal courts around the country. And for most of my career, I was a senior attorney for the Alliance Defending Freedom, which is America's largest religious liberty defense organization. Our mission there was to keep the door open for the spread of the gospel. So that's my perspective and my viewpoint. You should know that. And, we fought tooth and nail on every single issue over all those years where there was a hint of any small chance to defend or advance religious freedom. And we won 90% of our cases. But what we got, and, I previously represented Bossier. In the 2005 case at Stockwell Place, they were challenged for the nativity scene display and equal access for Christian clubs. We won that one. In 2015, people remember ACLU. The ACLU went after Airline High School because the FCA had a prayer request box in the student display area, and the principal used "God bless you" in an email. Everybody remembers that. So we fought there because we knew we were right on the law and the facts and that we could prevail in court. Right now, we've got a different situation, and this is what people have to recognize, that this latest case is different because the plaintiffs here, they gathered more than 5,000 pages and recordings of school documents under a Freedom of Information Act request before they filed the suit. And they presented all this hard evidence to the court of clear violations of very well-established law. Now, let me clarify this by saying, guys, this is not what we think the law should be, okay? That's not the question. The question is, what is the current state of the law, whether we agree with it or not? And in the school district, they had to answer the lawsuit under oath, so they had no choice but to admit to the well-documented facts. And they had no choice but to update their written policies. They're under penalty of law here. This is what the courts require. They have zero choice in the matter. So if anybody's upset with the school district or school board officials, their frustration is misplaced. It needs to be on the courts and what's happened in the courts over the last, 50, 60 years. That's
Does
the problem.
Does this policy change? Is it going to satisfy the lawsuit, do you think?
I think it moots the lawsuit, and it's exactly, precisely what the district had to do. They had no choice in it. People say, why don't they just keep, fighting this in court? Why don't they keep litigating? Well, Erin, this is a really important point. Now, people have to understand the board is fighting vigorously on every available inch of ground to preserve religious freedom for the students, right? The board members ought to be applauded for those efforts. But if you fight on well-settled points of law, teachers praying with students, for example, that issue was decided by the courts 60 years ago, 50 years ago. If you fight on it, it's totally futile. It's even counterproductive because consider this. If they keep fighting, they're going to risk, number one, a terrible court precedent that could be used as a weapon by atheist litigation groups, as some new weapon in their arsenal to further attack and erode students' rights to religious expression. And number two, it could risk an enormous adverse attorney fee award, and taxpayer dollars are scarce in this parish as elsewhere. And that attorney fee award goes to the atheist groups when they win. That'll just be used by the groups to further advance their radical secularist agenda nationwide. So why in the world would we want to contribute to that as taxpayers out here? And then third, it creates further confusion. We've got a lot of well-intended students and parents, teachers, coaches, school officials in our area. They genuinely want to understand and support students' rights and uphold these cherished traditions in every way that's legally possible. When you obscure the matter, it makes it more difficult for everybody. So I'm just saying, this board, they have no choice in this matter. They are stuck. The law is the law, whether we like it or not. And there's ways to change the law, but we got to do it through the courts, and it's going to take us decades to turn back this tide.
Mr. Mike, to what degree do you think that the Bossier, that the school boards, that the school district's legal counsel went in writing that policy?
They went right up to the line that they were forced to go by the court precedent. Guys, if we had time, I could walk you through all these courses. I mean, for decades, there are volumes of case law specifically prohibiting teachers and coaches from leading or participating in student prayers. I mean, Lee versus Wiseman, Supreme Court, 1992, Abington v. Shemp, 1963.
But pardon me, my question was going to be, I mean, when you get into such hair-splitting detail as if a student is praying or students are praying, that teachers on the scene can't bow their heads, are there instances of this kind of hair-splitting detail, to use my term again, in other districts and other cases around the country, or is this a first?
No, it's been well decided in many cases, and in the Fifth Circuit. That's the important point. We're in the Fifth Circuit Court of Appeals. That's Texas, Louisiana, Mississippi. That's the last step before you go to the Supreme Court. So we have Supreme Court precedent and Fifth Circuit Court precedent that requires this. But what does it mean in common practice? That's the big question of the morning, right? I had a public school teacher in Bossier stop me at church on Sunday, and she said, what if I'm standing along the wall of the gym during a genuinely student-led, student-initiated prayer? Does this mean I can't bow my head anymore? And I said, look, the answer is that common sense has to be applied in every situation, right? That the written policy prohibits teacher participation in prayer because the Supreme Court and the Fifth Circuit say it must do that, right? But here's the thing. You have to apply common sense. The question is, the courts have said that teachers and coaches and all that can show respect and deference, quote unquote, to student religious beliefs. Is quietly bowing your head while you're standing along the back wall of the gym showing reverence and respect, or does it cross the line into a so-called state endorsement of religion? The courts use a reasonable observer analysis. What would a reasonable observer see in that simple act? Would they say that that's an endorsement, a state endorsement of religion? Or would, I think we could argue, a reasonable person would see that as a personal act of reverence and respect. And I don't know if a plaintiff would file a suit over that subtle thing. I think it would be crazy if they did. But if we had that case in isolation, man, we'd fight tooth and nail on it. But the problem is we have this long trail of facts that these districts have to deal with, and they just simply don't have a choice. They have to follow the law because they've taken an oath to do that. And so, any frustration, again, is directed towards the courts, not to the public officials who are having to abide by this stuff. They don't like it any more than any of the rest of us.
Mike, let me ask you, there's one piece of this that troubles me, and it's regarding reading the Bible. It says that students can read the Bible or other religious texts before or after school hours, during lunch or recess, or during time set aside for student club meetings. So if my son or daughter finishes their work during class and decides to pull out the Bible and start reading the Bible during class, that's illegal.
No. That's not illegal. And what the policy is saying is, where the courts are on that, they say Bible reading, private religious expression, totally fine if it's on their own time. In other words, you can't pull out your Bible in the middle of an algebra assignment and say you want to do that instead, right? I mean,
okay.
That's just common sense. But if they're on their own time, they always have the right. And that's the important point here, Erin.
But it says permitted before or after school hours only. That's why I'm like, why'd they have to pin it down? You follow me?
Yeah, no, yeah. Well, look, I don't have the language in front of me, but the district is very clear and very resolved. They're going to defend students' rights every inch. And that's, we've had assemblies out there. They're promoting the materials. Attorney General Jeff Landry and I published the Louisiana Students' Rights Review to hammer that point home. They sent it around to in Bossier, they sent it around to every family in the school district to say these are students' rights. They're vigorously defending those. So, students don't shed their constitutional rights at the schoolhouse gate. That's an axiom in the law that's been there since the 60s. So they're going to vigorously defend that. I mean, they're doing the best they can under a difficult situation. I know the board members in Bossier and Webster, for that matter. Look, most of these people are Bible-thumping evangelicals, okay? They don't want to do this. Their hands are tied by activist courts. And, guys, this is a battle that we've been waging for decades. It goes back to the 60s. We've lost a lot of those. And the reason we lost is because people of faith, basically allowed it to happen. I mean, the church effectively was asleep at the wheel for several decades. So here we are. How do we change it? Elections have consequences. You have to elect presidents who believe in the Constitution, who are conservative, who will appoint conservative judges, and then we gradually turn back the tide in the courts. There's some hope that we can do that now, but it's not going to happen overnight. In the meantime, public officials they take an oath to uphold the Constitution and respect the law. They have no choice in the matter, and that's where this situation is.